Time is now 10:07. I will call the January 15th Planning Board meeting to order. As the following board members with us today, Vice Chair Giraldo,
Good morning.
Commissioner Okoye. Morning. And I am Chairman Barnes. We will now move forward with the business at hand. Please note that the deadline for all participation, pre-registration, and all submission of materials and exhibits was 12 noon on Tuesday before the Planning Board meeting. Please note that walk-in speaking, sign up are no longer permitted. We will now move on with today's agenda. The order of cases for today's meeting is as follows: item 2, 5, and 6. The first item on the agenda, item 2, draft minutes of January 8th. Look for a motion.
Mr. Chair, I move that we adopt the minutes from the meeting of January 8th.
Mr. Chair, I second this. Been properly moved to second. I will now call the roll. Vice Chair Giraldo.
I vote aye.
Commissioner Poirier. I vote aye. And I vote aye as well. We will now move to the regular agenda item. The first item on the agenda is a remand by the District Council for conceptual site plan CSP-23002 Signature Club East. Before we hear from Mr. Staff, this item is a remand from District Council. The District Council remand asks the Planning Board to take additional evidence on 9 issues. I will now open up the hearing. We will now hear from staff who will present these items. Mr. Hunt.
Good morning, Mr. Chair and the Planning Board. For the record, my name is Emery Huang with Urban Design Section. Item number 5 is conceptual site plan CSP-23002 for Signature Club East, which is for the development of up to 300 multi-family dwelling units and 12,600 square feet of commercial retail space. The property for this project is located in the northern east quadrant of the intersection of the Berry Road and Manning Road East. The property is located within the residential multi-family 48 zone. However, this case is being reviewed under the prior zoning ordinance, and his prior zoning is mixed-use transportation oriented. This conceptual site plan, along with Type 1 Tree Conservation Plan TCP1-052-97-03, were approved by the Prince George County Planning Board on July 10, 2025, and the final resolution, Prince George County Planning Board Resolution Number 2025-057, was adopted on July 31, 2025. The Planning Board's decision was appealed to District Council. On October 21, 2025, without conduct oral arguments, the District Council directed the preparation of an order of remand on all issues raised in the appeal. The order of the remand was issued by the District Council on November 4, 2025, which found the Planning Board's decision lacking sufficient well-reasoned and articulate administrative findings to ensure the District Council to conduct meaningful review, and requested the Planning Board conduct a hearing to take additional testimony on 9 issues. On December 8, 2025, the applicant submitted a revised conceptual site plan proposing a mixture of townhouse units and commercial retail space. The previous proposed multi-family dwelling units was replaced with townhouse units. Given that the Planning Board previously reviewed and approved the multi-dwelling use, Step 5, the changing this use to the townhouse use cannot be addressed through a remand hearing. On December 30, 2025, a staff memorandum was published responding to all issues in the order of remand and recommending 1 additional condition. As a matter of housekeeping, prior to the January 13 noon deadline, the applicant submit 14 exhibits to the record. This exhibit addressed the District Council's 9 remand issues through letters from the applicant's attorney and the memorandum of the applicant's experts. The applicant also providing a history of his community outreach efforts and his experts' resumes. Staff also received 7 exhibits opposing the proposed development. This consists of letter of the opponent's attorney and supporting exhibits. These supporting exhibits consist of correspondence from the applicants, prior tree conservation plans, and the report and resume of Mr. Lawrence Green. The letter and the exhibits raise 6 arguments. The first 3 of these 6 arguments are outside the scope of this remand. These are the sufficient of the applicant's community engagement, whether the applicant's proposal for townhouse is before the planning board, and whether subject conceptual site plan conforms to the condition of the approval for a previous conceptual site plan for the subject property. The other issues raised by the opponents will be addressed throughout this presentation. I will now turn to the remand issues. Please move to slide 13 of PowerPoint. Issue 1 is about the history of prior tree conservation plans regarding Lot 12 and All Parcel V covered by this subject conceptual site plan. This slide shows the subject concept site plan is a part of large project covering approximately 343 acres. The overall project areas require a total of 147.2 acres of woodland conservation. As proposed, this phase of TCP 1-052-97-03 for the conceptual site plan requires 1.61 acres of woodland conservation, which the applicant proposes to meet in an off-site mitigation bank and shall be purchased prior to first permit of the subject development. 12.55 acres of woodland requirements for the overall site was deferred from previous phases of the development. The deferred area was previous and incorrectly calculated at 7.81 acres. Recommended condition 1E and the associated analysis of steps memo will be correct to prior to certification of conceptual site plan, correct woodland conservation worksheet on TCP 1-052-97-03 to reflect the total of site mitigation required. Similarly, correction will be also be made in the amended resolution, which is item 6 on the agenda. In addition, page 6 of the staff's memorandum mistakenly note that TCP 2-039-01-03 contains a label of future development on Lot 12, which is incorrect. However, page 29 of Prince George County Planning Board Resolution number 17-153C for detailed site plan DSP-04063-04 associated with this TCP2, note that Lot 12 will be developed as a commercial facility in the future. The general note 13 on the cover sheet of the certified plan for DSP-04063-04 also notes future commercial retail on Lot 12. TCP 2-039-01-03 is for the revision to the site layout and unit type of residential development on Lot 12. Therefore, there's no intent for Lot 12 to remain a woodland preservation area. This error in the memorandum will be corrected before transmitting this memo to the district council. Opponents argued the subject property has been utilized to meet the woodland conservation threshold for other portion of the overall project, and therefore clearing is prohibited. Staff from the environmental plan section can provide further explanation, but the subject property has not been utilized to meet the woodland conservation threshold for any other development. Even with the proposed clearing, the overall 343-acre site is still above the woodland conservation threshold, as demonstrated on the applicant's woodland conservation worksheet. Although the on-site preservation is one method of meeting the requirement, the applicant has opted in this case to provide the requirement in an off-site mitigation bank. Remain issue 2 is about the property description. Staff agreed there's a minor errors in the property description which should be corrected with the amended resolution. Remain issue 3 is about the applicability of the transitional provision of the zoning ordinance. Because this application was accepted prior to April 1st, 2025, in accordance with Section 27-1900 sequence of the current zoning ordinance, it may be reviewed under the prior zoning ordinance. Remain issue 4 is about the conformance of the associated TCP 1-052-97-03 to applicable plans. Staff find this tree conservation plan is in conformance with county-wide green infrastructure functional master plan and the subsequent area master plan revisions. Opponents argued that this tree conservation does not conform to policies 4.2 and 7.1 of the Green Infrastructure Plan. Staff find that this tree conservation plan conforms with this policy per pages 9 and 7 of the staff memorandums. Staff also would like to make a very minor correction to this memo. The response to the remand instruction 4 at page 7 references section 27-542A2 of the prior zoning ordinance, but it should be referred to section 25-121A5 of the 2010 Prince George County Woodland and Wildlife Habitats Conservation Ordinance. Regarding issue 5, Staff 5 TCP 1-052-97-03 is not subject to the requirements to provide a justification for clearing priority for its content in section 5-1607C3I Natural Resources article of the Maryland Code. Opponents state that this provision took effect on July 1st, 2024. However, this provision is contained in section 1 of the House Bill 1511-2024. Per section 10 of this bill, section 1 takes effect July 1st, 2026. Remain issue 6 is about compatibility. With additional analysis and information provided, staff finds that through form and design standards, the proposed development is compatible with other off-site existing and proposed development in the vicinity and meet the intent of prior zoning ordinance. Opponents argue that the proposed multi-family buildings are incompatible due to height. As discussed in staff's memorandum, the arrangement of the proposed buildings, setbacks, and the required landscape buffers render the multi-family buildings compatible with surrounding development. Remain issue 7 is about the adequacy of transportation facilities. The applicant submitted a revised traffic impact study dated December 15, 2025, which includes the analysis of Condition 5 of the Prince George County Planning Board Resolution Number 2025-057. Staff find the proposed development meets the transportation adequacy standards. In so finding, staff analyzed the traffic impact study according to the 2022 Transportation Review Guidelines, which will apply to a future certificate of adequacy for this development. Opponents argue the conceptual site plan's finding impose a higher standard, staff disagreed, and interpreted the transportation adequacy requirement in the conceptual site plan's findings the same as the findings required at the time of the preliminary plan of subdivision through the certificate of adequacy. This is due to the references to the subdivision regulation and preliminary plans in the findings at issues. Remain issue 8 is about granting a variance for removal of specimen trees. Staff find no further testimony is required because the order remain directed the planning board to apply in correct legal standard to the applicant's variance request. Opponent's attorney raises a serious argument about the adequacy of the specimen tree's various findings. Given specific text of the remand instruction, staff do not believe these issues to be before the planning boards. Remain issue 9 is about the requirements of the storm water concept plan in accordance with section 27-273E14 of the prior zoning ordinance. The unapproved stormwater concept plan 35682-2023-SDC was submitted with this application and was accepted on February 26, 2024. Move the next slide, please. Urban design staff recommended the planning board reapprove the conceptual site plan CSP-23002 and issue an amended resolution, which is Prince George County Planning Board Resolution number 2025-057A. This concludes their presentation. Thank you.
Thank you very much. Are there any questions from the planning board? Seeing none, we will now hear from Mr. Gibbs. Before you, we'd like to swear you in.
Everyone intending to speak on this case, please stand. Do you swear or affirm that you will tell the truth? I do. Attorneys do? Okay.
You may begin.
Thank you very much, Mr.
Chairman, members of the planning board, Edward Gibbs, an attorney with offices right here in Largo. I am here once again before you on this case on remand this time. Thank you. Thank you.
And this time, not as a new case, coming back
to you on specific issues. And I might add that the record will reflect that when the appeal was filed to the district council by the opposition in this case, I filed a response to that appeal. But at the very outset of my response, I requested a limited remand because I didn't feel that there was sufficient information relative to the history of the tree conservation plans. This is its own application, no question. It is lot 12 and out parcel B. However, Signature Club at Manning Village is 343 acres. It spans years of approvals. And so because of that, when the case went to the district council, I stood up when I was called first. And I said, I'm not going to get into the issues of the case. I'm going to ask for a limited remand because I think that the tree conservation issue needs to be more thoroughly vetted and we need to put it to rest. And that's all I argued before the district council. There was no argument on the merits of the case before the district council. The district council simply said, we're going to remand and and there were remand requests made by the opposition in their papers. And so the district council simply said, we're going to remand on every issue where a remand was requested. And then we got this order. So that brings us back here today. I'm likely going to be back up here responding to issues about community outreach, which we think has been diligent and very comprehensive. But I'm not going to anticipate those items. There's criticisms that have been made in the papers filed by the opposition, which we vehemently dispute. And I will get into that once it's raised or when I come back. We have with us today Mr. James Clark, one of the members of the ownership team, Signature 2016 Commercial LLC. He's with us this morning. I have our land planner, Mr. Mark Ferguson. I have our civil engineer, Mr. James Buheister of VICA, and our transportation engineer, Mr. Michael Lenhart of Lenhart Traffic Consulting. The issues that came back on remand are all set forth in the order. I agree with staff's analysis that some of the issues that the opposition brings up before you today are not responsive to the items that were sent back on remand, and they shouldn't be considered today. I will say this. I am going to have each of my witnesses respond to areas that are within their area of expertise, because I think they can do it far better than I can simply just trying to summarize what their reports are. So I'm going to have them each speak. There are a couple of things, however, that I want to say. I do want to say that the allegation that we couldn't file this case because of the provisions of Section 271704, or the transitional provisions in the new zoning ordinance, are simply unfounded, because Section 1900 through 1907 of the new ordinance expressly conferred the right between April 1 of 2022 and April 1 of 2025 to file any case that you wanted using the prior zoning ordinance. And what we did here is we came in, the prior approval was for 157,500 square feet of commercial retail space to be built on lot 12. Out parcel B came into ownership because it was part of another parcel called parcel 25. Parcel 25 needed to be added to the Signature Club development in order to provide access out to Manning Road. You couldn't get access on the Maryland 210 Indian Head Highway. Obviously, it's an expressway. You also couldn't get access directly onto Berry Road. It is an arterial roadway. So you had to come out another way. The property owners before us purchased parcel 25 because it had frontage on Manning Road. That was used as the access to get out. It became, one part of it became out parcel A and B, another part became out parcel B, and this is the part that my clients acquired. So what we determined to do was to utilize the provisions of the transitional provisions of the prior zoning ordinance, and we filed a new conceptual site plan within the 3-year period. And therefore, we were entitled to do that. There was nothing legally erroneous about that whatsoever. So the assignment of error is simply without merit. We also talked about compatibility, and let me get to that. One of the issues on the was to discuss the issue of compatibility. When we had filed the original application, we asked for approval in this conceptual site plan of up to 300 multifamily residential units and 12,600 square feet of commercial retail space. Now, bear in mind, under the new ordinance, the property is zoned RMF 48. That zoning classification stands for residential multifamily at 48 units to the acre. That's the residential that you can do in that zone that is assigned to this property today under the new ordinance. We were going under the prior ordinance using the MXT zone, because that is how the balance of Signature Club had been developed, and we wanted to stay with consistency. When we went through the process, we heard a lot of complaints about multifamily. Questions like, are there any other multifamily in Accokeek? No, that's right. That's how it should stay. We don't want that. There were concerns about traffic associated with multifamily. Notwithstanding the fact that, bear in mind, in the CMA, the district council assigned the RMF 48 zone that only allows multifamily. But be that as it may, we listened. And so when the case was remanded and when we thought it over, I recommended to my clients, why don't we cut back? Why don't you amend your application to request no more than 180 residential townhomes? Fee simple use, less density, less traffic, less environmental impact. We did that in an effort to be considerate of the concerns that were raised, at a substantial density reduction and overall economic vitality of the project for my client. And it was for that reason that we filed revised plans. We filed the request to formally amend the application to request residential townhomes. Now, staff does not want to review that on the remand. I understand their rationale. However, I have scoured the zoning ordinance. I cannot find in the prior zoning ordinance one provision that says we cannot do this. There's nothing that says you cannot do it, especially when you're doing it to address an issue of compatibility, which we were charged with looking at in the remand. And remands, it doesn't have to be a remand de novo for things to change. The whole point of a remand is they want you to look at some additional things, clarify some other things, so forth and so on. We think that the request to amend the application to request townhomes as opposed to multifamily units is permitted. We appreciate and respect staff's position that, well, that wasn't on the remand, but there were a lot of things that were noted in the remand that could have resulted in changes. And it doesn't mean that you can't do it. So we think because it's an ameliorative effort on our part, an outreach effort to try to do less density, to try to be responsive to comments that were raised, to objections that were raised, we think that's a permitted change to the plan. It's not increasing intensity and density, it's reducing it. So that's just our position on it. I understand what the staff's position is and what their recommendation is, but we think it can be considered. If the board chooses not to, then we think the original approval could stand. But that's not what we're looking for. We're looking for a reduction.
Mr. Gibbs, I just want for clarity. So what you're saying is that the plan that we approved previously was for multifamily, and what you've done now is submitted a revision for purposes of taking into account the views of the community. So to take out the multifamily and replace it by townhomes.
Sir, that's exactly it. And again, one of the 9 issues says look at compatibility. And we heard comments during the first time around that multifamily was not viewed by the residents in the area as being compatible. Now, personally, it's permitted in the MXT zone. I've done MXT projects where we have multifamily, single family detached, and townhomes all in the same project. Certainly multifamily can be compatible. It can be. You can make it compatible through design, so forth and so on. But we decided and determined that we would basically cut back the project for that reason, because it does fall under the issue of compatibility. Sorry?
Laura Tallarico for the record, just to put a little bit more meat on staff's position since Commissioner Giraldo was asked about.
I'm truly not criticizing staff.
No, just kind of the
Sure.
pieces in approach is when staff approached this remand, they look at it as a remand of what you previously approved, critiquing the decision to approve multifamily. Townhouses is an entirely different project from what was previously approved. So what we're looking at today is that prior approval for multifamily and whether that was correctly done. So we're not considering the townhouse. That is the reason that staff and legal believe that the townhouse proposal is not before the board at this time.
Okay, thank you.
And I truly respect that comment. I would object. It is before the board because I filed it, and we filed an amendment. And I just think that if you're on remand, and one of the issues is compatibility, and it's been raised as a compatibility issue, and we're actually reducing the development. We're cutting it back. It's worthy of consideration. That's all I'm going to say. I recognize and respect the position that was just articulated by your counsel. But I also have had conversations with counsel for the planning board, and I have been told that no one has any objection to me taking the position that I've taken and making the comments that I've made, because I do believe it's a compatibility issue. But I also believe that the multifamily as originally proposed can be compatible as well. I'm just saying that we will do the townhouses if it gets approved. So that's it on the compatibility. And I think, let me just say that the staff report I find to be thorough and in general, very well reasoned on basically all of the issues. And my witnesses have prepared reports that we have put into the record, which augment those issues on remand and in particular on compatibility. And so I am going to have Mr. Mark Ferguson and come up here and talk a little bit about the compatibility issue as well. He covered it in the report, but he will summarize it. The other big issue was the transportation adequacy. So this case has a pretty good history. And so we filed an original transportation impact study that was back in November of 2023. And we filed a revision in May of 2025. And then more recently in December of 2025, we filed yet another revision. So when the original transportation study was prepared, it was vetted with staff. A scoping agreement was arrived at. There were a number of intersections that we were charged with looking at. And we looked at the way they function today. We built in a growth factor over a period, I think it was 6 years. We looked at approved but unbuilt developments, and then we put in all the traffic that would be generated by this project. And make no mistake about it, there's a lot of traffic on Maryland 210. I've traveled it for many, many years. And so I understand concerns that are articulated, but we followed the letter of the law. And after all of that analysis, one intersection, that's the Indian Head Highway 373 intersection, had a failing time in the PM peak hour, So what we did is we went and we looked at mitigation. Mitigation is permitted, People can say what they want, but it is expressly permitted. And we went through and identified in the December report certain mitigation improvements. And when you use mitigation, you have to mitigate 150% of the trips you generate. 150%. The improvements identified by Mr. Lenhart in his report mitigates 300% of the impact of our project. 300%. And so when you read the letter put in by the traffic engineer on behalf of the opposition, he says, well, wait a second, they're proposing to reduce their units. And so the cross-pollination between the retail and the residential here is not going to be as great. And so you're not going to get that trip reduction. Well, when you're mitigating 300% of your trips, that's a meaningless comment. It is truly a meaningless comment. And Mr. Lenhart will address that when he gets up here to speak as well. So I think I'm personally going to stop at this point because I have witnesses who I want to bring up, and I'll be happy to answer any questions before I do that, sir.
Are there any questions for Mr. Gibbs?
None at this time.
I'd like to bring up Ferguson. So.
Good morning, Mr. Chairman, Commissioners. Mark Ferguson with RDA Site Design Offices in historic downtown Upper Marlboro. Let me actually ask a clarifying question of Mr. Gibbs. Did you want me to limit my comments at this time only to the compatibility issue? Or did you want me to speak to the priority forest question? Or
I think you should address the issues in your report. Yeah. In order to get as much before as possible and limit remote.
Okay, thank you. So I did prepare a report which was submitted to address items 4, 5, and 6 of the remand order. Item 4 was the first, which was whether the first item that I covered in my report was whether the TCP2 as amended conforms with the Green Infrastructure Plan and subsequent area master plans. And I think certainly I agree with staff's report. What I would expand on, and I do think it's important, is that the goal of the Green Infrastructure Plan is to support, it's one goal, and it starts, support the desired development pattern of Plan 2035 by preserving resources and increasing connectivity of built and natural green spaces and all of those other things. So all of the policy items that the staff did review in their report do need to be seen as implementing the goal of the plan, which is to implement the desired development pattern of the larger general plan, and in fact the master plan. And the planning for this property since the adoption of this plan in 1993, when I'm old enough to have been practicing back then, has been for the mixed-use development of the property in the way that it's been described. Low density in the RA zone portion on the south side of Berry Road, higher residential density on the RR portion south of Berry Road, the shopping center that's there now, that's now in the CGO zone, the MXT development on the north side, both of the existing portions of Signature Club and the last remaining parcel of that piece, which has been comprehensively planned since 1993 when the zoning was put in place. The general plans generalized future land use for this property. It's mixed use. That's the highest density that is provided for in the general plan's land use categories. The master plan recommends mixed use development for this property. And this is the 2013 master plan, not just the one that's from 30 years ago. It's interesting to note that the subject property and the area you can see on the screen that's now dirt but is going to be developing, those portions the master plan recommends for mixed use. Actually, the existing Signature Club The existing townhouses to the rest don't even have that mixed-use land use recommendation. So it really is this site, which is now and has been for a long time planned for the intense kind of development that's being proposed, and all of the policies of the Green Infrastructure Plan are in place to implement that overall land development. What I will move on to on the second part of my report was the fifth remand item, which was whether or not TCP2 05297 proposes to remove priority retention areas, and if so, provide written findings and justification for such removal as required in Natural Resources article, et cetera, et cetera. I actually disagree with staff and agree with the opposition that that provision of the state's law is enforced today. That specific portion was made to be in force as of July 1, 2024, pursuant to HB 1511. However, that same bill provided that the provisions of this plan, of this bill and the state law don't apply to plans that were approved before 2024. What we have before us is a minor amendment to a plan that was approved first in 1997, which is almost 30 years ago. Again, a continuation of a consistent planning process that has been going on for 30 years. And this site represents the last part of it. The CSP may have a limited area for technical reasons, but the TCP does not. The TCP continues to cover all of those 343 acres, and the provision and the conformance of that TCP to all of the goals in the Green Infrastructure Plan and in the master plan have to be viewed in the context of its totality, not just a little corner of it. And to that end, even were the provisions of HB 1511, Section 51607 of the Natural Resources article applicable to this TCP, which they aren't because of its age, priority forest in that area, a priority forest in that legislation is described as the largest undeveloped tract of land within and adjacent to the site. In the context of that overall TCP, the largest undeveloped tract of land is the Mattawoman Creek Stream Valley, which is and continues to be protected by this plan. One of the things that staff also does not mention regarding priority preservation areas is that the county's Woodland Wildlife Preservation Ordinance also contains priority preservation areas, and as a priority area, but they're defined differently. And that is contiguous wooded areas with high structural and species diversity, few non-native and invasive species present, very good overall stand health, and high potential to provide a significant amount of habitat for forest interior dwelling, plant, animal, and bird species. Now, staff already did discuss in their findings that the little bit of forest in the context of the 343-acre tree conservation plan is actually fragmented because of Berry Road and Manning Road and the stormwater management pond, which has already been put in for a portion of the development and the access roads. And so it doesn't support FIDS species and doesn't meet that contiguous forest standard in the county's ordinance. So I state those things to supplement the staff's findings. The final issue I cover in my report is item 6 of the remand regarding compatibility. And I actually think the staff did a very comprehensive job in their discussion on that. they are absolutely correct. The issues of compatibility have to be viewed in terms of separation, in terms of building height. But there are other things that further speak to it. This is a residential use, whether it's multifamily or whether it's townhouses. The MXT zone also admits of much more intense uses, like the commercial development, for instance, which is proposed on the subject property, but in a way that's removed and buffered from the surrounding development by the proposed residential development. So you already have a step down of intensity of use from Berry Road back to the surrounding neighborhood, and that amplifies, I think, what staff already has given you in their report. So I think that's things that I've given you that I think they're bringing up. And Mr. Gibbs, if you have anything else you'd like to cover? Okay, thank you.
Are there any questions?
Thank you. I'd like to have briefly our civil engineer from RICA come up and say a few comments about.
Svota is standing up behind you, raising her hand.
Sorry, I don't want to shout. I don't know if it's appropriate. Should I come up?
She wants. She is frightened about that.
All right, come on up.
For the record, Alex Bota from the Law Office of G. Mason Nelson for citizen protestants in this case. I did want to cross-examine, but I don't want to be intimidating and be right next to the witness. Could I get some guidance on the best way to do this so I'm not right on top of the witness and we both have access?
I'm certainly not intimidated.
Okay.
So what it's
Okay.
Go ahead and proceed.
I know sometimes that's frowned upon, so I just wanted to make sure. I recall in your testimony you stating that this property has always been designated for mixed-use development. Is that correct?
Well, certainly since the adoption of the 1993 master plan and sectional map amendment. The caveat to that is that the slice of the property, the triangular slice of the property that has in the past been known as the Vincent property that Mr. Gibbs talked about, that was acquired to provide access. That was added to the assemblage subsequently and was granted MXT zoning in 2006 as the result of an application, an individual application rather than the comprehensive process.
And during that entire time, the Forest Conservation Act's requirements have been in place. Is that correct?
Which Forest Conservation Act are you referring to?
Whichever one applies in this case.
In my opinion, and I believe, Mr. Huang, you read from a resolution earlier regarding the future development of the CSP. Did that resolution not contain a statement that the TCP, the standards applicable to the TCP were the 1992 standards?
Sorry, Tom Work with the Environmental Planning Section, Countywide Planning Division. I'm sorry, can you repeat the question?
I believe that resolution, Mr. Gibbs, do you have a copy that we had discussed a resolution? Mr. Gibbs and I had discussed a resolution from one of the prior Signature Club cases that there had been a finding of the planning board that the prior plans had been reviewed under the 1992 ordinance. Is that correct?
Let me check on that information for you. I'm sorry.
No, thank you. Appreciate that. And that is my belief that the 1992 standards are the ones that would apply to the subject property, to the subject TCP. Mr. Gibbs has handed me a copy of Resolution 17-153, and reading from page 27, the finding is regarding Prince George's County Woodland Conservation and Tree Preservation Ordinance. The project is grandfathered with respect to the environmental regulations contained in subtitles 24, 25, and 27 that came into effect September 1, 2010. because this is a revision to a previous detailed site plan approval, DSP 4063-03, that was approved prior to this date. The current approval request does not affect the grandfathering status of the project. A type 2 tree conservation plan, et cetera, was submitted for review. So based on that, it is, and my own analysis. Thank you. It is my opinion that the 1992 regulations are applicable. And yes.
I think I'm being instructed to hand you this microphone to use.
Perfect.
All right. I perhaps made this more complicated. The point I was trying to make is at every time during the course of this development, there were forest conservation regulations that require the preservation or conservation of a certain amount of woodland on site or through mitigation. Is that correct?
That is correct.
So it's not the case, is it, that all prior general plans or zoning regulations contemplated that the applicant must remove every single piece of woodland on this site? Is that correct?
I'm sorry, could you restate that?
Yeah.
Did a couple of circles.
Yeah, so the zoning ordinance previously, the MXT zone, I'll start with that.
Yes.
Did that require the applicant to remove all of the woodland on site?
The zoning ordinance did not, no.
Did the Forest Conservation Act require that?
Did not.
Does the general plan require that?
Does not.
So in every circumstance, the general plan, the zoning ordinance, the Forest Conservation Act, there's an idea that there would be a balance between development and forest conservation. Is that correct?
I would not necessarily draw that conclusion. I mean, certainly each of those ordinances, plans, stand on their own.
So when you say, for example, that mixed use development is the highest density allowed, again, there's no requirement that a mixed use development has to remove all of the woodland on site. Is that correct?
That is correct.
Okay, that's what I thought. I just wanted to make sure that was clear. That's not required for a mixed use development. The other question I wanted to touch on is regarding the compatibility. So I just want to make sure I'm clear. The height of a given structure, that impacts whether it's compatible. Is that correct?
It is one component of compatibility.
And are you able to identify any property in the vicinity of the subject property that has a four-story development on it?
In the more limited area that I described as the vicinity of the property, no.
Okay, so there are no properties in the vicinity that you looked at, for example, in your testimony, that have 4 stories. That's correct?
That is correct.
So, in other words, a 4-story development of any nature, whether that's multifamily, whether that's townhouses, whatever the structure is not compatible with the less than 4-story developments in the area.
I do not agree with that statement, though.
I'm sure that's a point I think is important for the board to consider. The last question I want to ask is about the previous. Yes.
So no statements, no questions. That previous 4-story comment seemed more of a statement.
Got it. Understood. I'll bring it back up when I get back up here. The last question I had is about the prior tree conservation plans. It's true, is it not, that the tree conservation plan for Manning Village, I believe the number is TCP, let me see if I can find the number on here. I have it cited in, I just want to be precise. The board indulge me for one moment. So TCP 2-039-0103, I believe that was approved around 2017. Part of the forest conservation calculations for that property, which again is the Manning Village development, contemplated satisfying the tree conservation requirements through the preservation of woodland on lot 12. Is that correct?
That is correct. So, and the TCP you're referring to would be Signature Club at Manning Village.
Okay, great. Sorry, I apologize for that mistake. So again, when the previous development that included lot 12 was determining how much preservation or conservation they had to provide, part of that calculation included the preservation of woodland on lot 12. Is that correct?
I would say the correct way to state that is that at the time of that TCP2, which is not before the board, part of the conservation requirement for their development, which was Signature Club West, was satisfied by the designation of tree preservation area on lot 12.
And do you know if the developer at that time for the Manning Village development had clear-cut lot 12 as is being proposed in your development, would the developer in that case had to be required to provide more woodland conservation than they were previously required to provide?
The short answer is yes. The long answer is more complicated because we have TCP1s and TCP2s that you're kind of mixing and matching. The overall TCP1, which has always contemplated clearing of lot 12, had always ultimately provided that preservation would be provided for that clearing. The TCP2, which again is not before the board, did satisfy some of its requirement at that time by preservation on lot 12. What is being proposed is to complete the implementation of the TCP1, which had proposed future development, and in doing so, we'll need to provide we'll need to clean up, in other words, all of the remaining conservation requirement for everything within the whole of TCP1 -52-97, whatever that may be. This is the last bit. So if there was something that got missed before, it has to be met at the end. If there's clearing associated with a subsequent TCP2 for the development of lot 12 and at lot B, it will have to be met.
And again, I just want to be clear, the calculation sheet for the Manning Village development, that lays out the amount of woodland subject to that TCP. Is that correct?
It lays out woodland for a part of the entire TCP1 area. So looking at a TCP2 for a portion of the entire development covered by a TCP1 is, number one, not before the board, and number two, a little bit misleading in looking at a TCP1, which is before.
With all due respect, it's this board's job to ensure that the Forest Conservation Act is being properly enforced and applied, correct?
Objection. Mr. Chairman, there's been continual testimony being provided here by counsel when she's supposed to be.
That's a question.
I agree. Stick with the question.
I'm sorry, I thought that was a question, but I'll rephrase. You know, I'm just going to wait till I get to my argument. I think we've established what I need to establish with this witness. Thank you for your indulgence, board members.
I have some redirecting as a result of that. Mr. Ferguson, questions or testimony by counsel led you to make some comments relative to the TCP associated with the development of the 313 units at Signature Club West. Is this in fact a copy of the detailed site plan resolution that approved that project?
It is.
And I would direct your attention to the conditions attached to that approval, and specifically direct your attention to condition 1J, and read that to the board, please.
That has to do with 65 DDA line. I think you mean 1K, revise the TCP2 as follows?
No, actually, it's
I.
yes, I.
The applicant shall indicate a note on the cover sheet of the landscape plans indicating that lot 12 is phase 2 of the subject project for future commercial development.
Okay, and that lot that's being referred to for commercial development, do you know whether or not that is the subject property here?
It is a portion of the subject property, yes.
So, in your experience, would this resolution be controlling over what is
I think what is, again, very clear is that the detailed site plan, which indicated an intended future development on the subject property, was reviewed in conjunction with the same tree conservation plan that opponent counsel was cross-examining me about, that does show tree preservation on the subject property. So it was understood at the time of that detailed site plan approval for Signature Club West that yes, there would be tree conservation on Lot 12 and that Lot 12 would be developed in the future.
Would that lead you to believe it was a placeholder?
Yes, it would.
Thank you very much.
Oh, yes.
Sorry. Yes, Mr. Chairman, I'd like to ask our civil engineer to come up briefly and give us some comments relative to plan approvals.
Morning, Chairman, Commissioners. My name is James Buheister. I work with VICA, Maryland, located at 4041 Powder Mill Road in Beltsville, Maryland. VICA is the record civil engineer for this project. We also offer the Forest Conservation Plan preparation services. I am a landscape architect, qualified to prepare landscape plans. I'm up here to basically talk to remand item number 1 regarding the history of the TCP2 and the various things that have been presented by staff, Mr. Gibbs and Mr. Ferguson. Effectively, I do agree with staff's very comprehensive and diligent summary of the TCP history, both 1 and 2. I make note of my letter that was submitted on previously that the various findings in the staff report are correct. I agree with them, and I've been working with environmental planning staff very closely over the last few weeks, especially up until this morning, trying to figure it out. And I say that because it's not that we're not able to, it's that the history, the 30-year history of this development, as was mentioned by Mr. Ferguson, there's a lot of plans, there's a lot of nuance, there's a lot of things that aren't known due to change in personnel, et cetera. We do the best we can with the plans that are available. We do the best we can with receipts and validation of woodland conservation offsite credits that have been purchased. And so what I will summarize in saying is that we've worked through the various worksheets, both individually on each TCP2. Again, just Mr. Ferguson has represented, those TCP2s are the mechanisms by which the TCP1 gets implemented overall for the 300 and some acre development. So I believe that we concur with staff's latest phase worksheet that shows the history of the plan, and we concur with those numbers.
Thank you.
That's effectively it.
Hold up.
Again, for the record, Alex Vota from the Law Office of G. Mason Nelson. Again, I just want to be clear on the numbers. So the prior TCP2 that we've been describing, it's true, is it not, that the applicant was not required to provide as much offsite conservation credits because they preserved woodland on Lot 12. Is that correct?
That is correct, with the understanding that it was a placeholder and that each TCP2 implements the underlying TCP1. And that has been the history of the project, where preservation has been done temporarily and then changed as the overall development was built out.
So at what point was sufficient offsite woodland credits purchased to make up for the clear cutting of Lot 12?
So Lot 12 has not been clear cut. The forthcoming TCP2 associated with the development for this lot will account for the forest conservation preservation provided by the temporary nature of this particular site.
I just want to turn back to the prior TCP2. Did you have a chance to look at that TCP2?
Very closely.
Okay, and you reviewed the tree conservation table, is that correct, on the front of it?
Correct.
And that table states, does it not, that there is a woodland conservation threshold of 9.65 acres, is that correct? It's not a memory test.
Yeah, that sounds correct.
Okay. And because the applicant in that case preserved the woodland on site, on lot 12, they were able to provide woodland conservation credits at a ratio of 0.25 to 1. Is that correct?
That is correct.
Because it was above the woodland conservation threshold. If they had clear cut or removed the woodland on lot 12, they would have been below the woodland conservation threshold of preserving 9 acres. Is that correct?
That would be correct if it were a standalone TCP2 that was the framework for the TCP1, but we look at the threshold established by the overall TCP1. So the TCP2 would reflect that the clearing that's being done on this particular site, it would be adjusted to account for the overall woodland conservation for the TCP1, for the entire 300 some acres.
So where on the TCP2 does it state that?
It doesn't, as far as I know.
Okay, and where in the Forest Conservation Act ordinance does it state that you can do that?
I believe it doesn't. I don't recall that the Forest Conservation Act specifically says that.
Okay.
It's a matter of practice that was done through the Park and Planning and Environmental Section over the last 30 years.
Okay, got it. And again, if the applicant in the Manning Village application had removed the woodland on lot 12 so that they were below the woodland conservation threshold, would they not have been required to replace the woodland below the threshold at a ratio of 2 to 1?
Under normal circumstances, yes.
Thank you.
Thank you.
Right, sir. To the last question asked by council, I'd like to present to you a copy of section 25-119 of the county code, subtitle 25.
Mm-hmm.
And I would direct your attention to section 25-119 C4 small I small bb. And is it not correct that envisions and allows that reduction?
Yes, that is correct.
Thank you. Thank you very much. You call Mr. Michael Lenhart real quick.
Just for purposes of the residents, can you explain what the placeholder means? Because we may know, but it may not be that residents understand that.
Sure, absolutely. What I mean by placeholder is that it was temporary in nature to satisfy the requirements at that time, effectively delaying the ultimate resolution of the TCP1 to be mostly woodland offsite credits on top of preservation of the forest in the Mattawoman stream area.
Okay, thank you.
Yes, Mr. Lenhart for some brief testimony.
Yep, Mr. Lenhart.
For the record, again, Michael Lenhart with Lenhart Traffic Consulting. I'll be brief. Just like to point out, I think that the opposition is going to state that the intersections are not all adequate. The subdivision regulations and the transportation review guidelines specifically expressly allow mitigation as a means of achieving adequacy. And I'd like to quote section 244505 B3 that states that transportation adequacy an existing revenue source to alleviate any inadequacy in the adopted level of service standard within the transportation impact area. This applicant has proposed improvements that will alleviate the requirement in the guidelines, and the subdivision regulations is a mitigation of 150%. This improvement will mitigate over 300%. Page 21 of the technical staff report in the backup materials quotes that the mitigation results in meeting the requirements of mitigating a minimum of 150% of the development site impact per the 2022 Transportation Review Guidelines, and therefore meets the adequacy requirement, end quote. Staff in their presentation today emphasized the fact that they agree that mitigation is provided and that adequacy is met. I would like to also emphasize that while this CSP is proposing to replace 300 multifamily units with 180 townhomes, the traffic study that we submitted for the record for this remand was based on 300 units. We also included an appendix for the 180 townhouse reduction. That was not the basis of the study. Staff advised us they would like to make their findings based on the original application, which was 300 multifamily units. We did that. That generates more traffic than what would be proposed by the 180 unit reduction. Therefore, the mitigation, we're providing the same mitigation. It's going to mitigate more of this site's impact than what is shown in this traffic study. That's all I have. Ms. Motel?
Thank you. Thank you. Oh, I'm going to hand you this microphone. Thank you. I just have a brief question. So you were just describing proposed mitigation efforts. Is that correct?
Sorry.
Yeah, absolutely. So you were just describing proposed mitigation efforts. Is that correct?
Yes.
But you also submitted, I can't remember the date. I want to say it was January 5th, January 10th, something like that. Okay, a letter stating that the applicant should be exempted from the mitigation requirements. Is that correct?
Yes.
So that's still your position. Is that correct?
Yes. However, we've proposed mitigation that does satisfy the requirements regardless.
Okay. And last question, the mitigation that you've proposed, have you submitted that to the State Highway Administration?
In conversation with the State Highway Administration on that.
Thank you.
So you have in fact had conversations with State Highway?
Yes, I have.
Okay, and
They have acknowledged that the proposed improvement would be of operational benefit and that they agree with the improvement.
right. And your January 5 memo, which is in the record, relative to your analysis of the requirement for further mitigation, are you proposing that to be implemented here, or was that for information purposes and you're accepting the condition through mitigation?
It was for informational purposes. The January 5th memo confirmed that we are proposing mitigating this intersection that satisfies the requirements, and then we included informational backup. And the fact is that this project already has a automatic certificate of adequacy issued April 1st of 2022 from prior subdivision approval that actually has more trips than what this project is generating.
Okay, thank you very much. Yes, Mr. Chairman, that basically concludes our initial presentation. We reserve the right for rebuttal. I would say that with regard to the specimen tree variance issue, we align ourselves with the analysis in your staff report. It's interesting because the district council remand order says that we should apply zoning variance standards to the specimen tree variance, and it's just flatly wrong. And what's further interesting is that the case cited in your staff report on remand cites the Bargava case, And Attorney David Warner, Chief Counsel for the Planning Board, represented the Park and Planning Commission in that case. And interestingly, counsel for the opposition represented the appellants in that case, where she argued that zoning variance standards should apply to a specimen tree variance. And the court flatly stated that is absolutely incorrect. And if you look at the statute itself in subtitle 25, it specifically states that a specimen tree variance is not a zoning variance. So that issue in the mitigation remand or in the remand order is simply wrong. The only other thing I would say is that the one thing I did make a commitment to some of the opposition that I would also proffer an additional condition to be added. Buffering and screening is going to be the subject of, assuming that we are successful with our conceptual site plan, it'll be more apropos at the time subdivision plan and detailed site plan. But I did make a commitment that I would proffer a condition to require site-tight 6-foot-high screening barrier along the entire northern boundary of our property. There will be a buffer there, make no mistake about it. But this is in addition because of concerns raised relative to those are two large parcels, one's 10 acres and one's 5 acres approximately. And both of those ownership representatives are here today. And I did make a commitment to them that I would proffer that as a condition to be added. Simply because of concern over trespassing and so forth once the property is developed. I would just offer that as a condition. Thank you very much, if I can.
Mr. Gibbs, so you're proffering that today, and that would be on lot 12?
It would be on both lot 12 and out parcel B, the entire northern
part.
Yes, sir. I don't think that's inappropriate.
No, it's not.
Thank you very much. That would conclude our initial presentation. Obviously, we have some rebuttal potential.
I know we have several in opposition. Ms. Fulton.
Thank you. Good afternoon. It's a pleasure to be before the board. For the first time in person, I've gotten to see you all virtually, so I'm excited to be here actually in person for the first time. Again, for the record, my name is Alex Vota from the Law Office of G. Macy Nelson. And today, I also have the pleasure of representing Carolyn Keenan, Jordan Eberst, Victor Christensen, Raina Dodson, Julian Dodson, and Caleb Dodson. Their addresses are in the record as well. I want to start my arguments by just a preliminary procedural matter. I want to make sure that we're clear. We are incorporating and embracing all of our prior arguments in this case. I want to make sure that I'm clear because I erroneously failed to include one argument in my written exceptions. We still hold very strongly to the argument about whether this CSP application is appropriate under the transitional provisions, specifically 27-1704A. I also want to make sure I'm clear that it's my understanding the record incorporates all of the prior testimony and prior documents that were before the planning board. So I just want to make sure that's clear for preserving the record purposes. What I really want to start with, members of the board, is the community engagement piece of this, because I think that's a repeated issue we've had. I know I've had representing citizens across the state in this county in particular, and has been noted by this board and by the district council. And just to give some examples, in the July 10th hearing on this case, the chairman stated, quote, "We're trying to transform Prince George's County to what we want it to be. And part of that transformation, in my opinion, is being good teammates, being good partners. Communicating with folks, letting them know that yes, change is coming, but I'm going to do all that I can to make sure that I am a good partner in that change." Similarly, Council Member Sydney Harrison at the District Council hearing on October 21st in this case stated, "I would really like both parties to work together with the community to hash out any differences or grievances and an understanding under the zoning laws what is allowed and what is not." But community buy-in is everything. It is everything. And I'd really like the community and the business developers that are looking to do some improvements on the property that they own, that they work with the community to build capacity that is harmonious to the community. And unfortunately, members of the board, that did not occur in this case. With all due respect to my colleague for the applicant, he reached out to me in mid-November and asked if my clients would be open to townhouses. I responded that my clients were not enthusiastic about townhouses, and their primary concerns were the density related to how it would impact traffic, its compatibility, and then also the tree preservation. And they were open to ideas that better balanced preservation of woodland and development of the site. My clients are very reasonable people. They're pleased to hear about the condition regarding the fence. But again, what they've consistently been asking for is a plan that better balances preservation of woodland, particularly given the ongoing flooding and sewage issues in this area. With the development of the site, again, they're reasonable people. They understand that this site is intended to be developed. And, you know, to be frank, it would have been helpful if my clients were approached with a plan that said, maybe it's townhouses, but we're reducing the footprint of the townhouses. So we're providing more on-site preservation and better landscaping. I think my clients would have been much more enthusiastic about that option. When I expressed my clients' concerns about not having that balance and instead proposing, again, a plan that clear cuts essentially the entire property, provides no on-site woodland, provides very limited landscaping based on the plan provided to the board. We were not met with any meaningful response. We were told on January 6th that they had submitted a plan for a townhouse and no further details were provided. And the applicant had already submitted the plan before contacting us that second time. So again, I think that there is some wiggle room. There is some commonplace that I think our clients would have been open to hearing. And I will, at the conclusion of my statements, which I promise will not be very long, provide some conditions that I think my clients would go a long way to meet community issues. One of those, again, is compatibility. Compatibility, yes, is about the use, but it's also about the scale of that use and the height of that use. As we've heard testimony today and we've heard testimony previously, there are no structures in this area that are 4 stories high, none. I think having a limit or a condition of approval, for example, that limits the height of any development on this site to 3 stories or less would go a long way on that compatibility issue. Same thing with the amount of screening. For example, there's a prior condition of approval that applies to this property that requires perimeter landscaping must exceed the minimum landscape requirements by 100%. That's already a condition of approval. I think if this board were to approve this plan in any way, a condition of approval that reaffirms all landscaping must exceed minimum amounts by 100%. That, again, would go a long way to addressing the compatibility issue. And I want to touch on the tree conservation issue. One of the main concerns in this case is that Lot 12, as we've heard many times at this point, was used to reduce the amount of woodland conservation required by previous applicants. I know that it's been designated or described as a holdover, but fundamentally what the prior applicants did in this case is say, we are going to preserve Lot 12 so we don't have to provide as much offsite mitigation. And in the calculation of offsite mitigation, if you are below the threshold, if you remove too much woodland, you have to replace that woodland at a 2-to-1 ratio. If you preserve enough woodland, the amount that you remove only has to be replaced at a 0.25-to-1 ratio. And what the prior developer did in the Manning Village development is say, we will get to reduce the amount of offsite woodland that we are providing by preserving Lot 12. We will not go below the threshold, and therefore we only have to reduce at a 0.25 ratio. We outlined in our objections, I don't see anywhere in the in the Forest Conservation Act that allows this type of behavior in the first place, or the removal of woodland once it's been designated for preservation. But if that is allowed, at the very least, the applicant proposing to remove land designated for preservation has to make up for the violative effect of that removal. In other words, we believe the applicant has to provide the conservation that would have been required had the previous developer removed the woodland on lot 12. And we outline in our written objections on pages 9 through 11, the math that goes along with that. So I know planning staff has identified, I think it's about an additional 7 acres of offsite woodland preservation that is required. Truthfully, I didn't 100% understand where that came from. My understanding it's from prior developments in the Signature Club that never purchased their offsite credits. This is separate from that. This creates an additional violative effect. And based on the calculations provided on the woodland conservation sheet, the applicant should be required to provide a total of 33.72 acres of offsite preservation, excluding, I believe, the 7 acres that was never purchased in the first place for other developments. That's the total we believe is required if the board is going to allow for the removal of woodland that was used to what seems like arbitrarily reduce the amount of woodland conservation previously required for the Manning Village development. We think that's a very minimum that needs to be required in this case. I also want to touch on the tree conservation variance. The request to remove, I believe it's 4 trees, primarily located along the border of the subject property. I acknowledge what my colleague has said about the case law regarding uniqueness for the property. And you'll see in our briefs, we've never asked for the application of the uniqueness test as articulated by the district council. What we focus on more specifically are requirements that apply specifically to Forest Conservation Act variances. For example, for the requirement that they demonstrate an unwarranted hardship, there is case law, primarily the West Montgomery case that applies to Forest Conservation Acts, that says the hardship you're experiencing, the reason you need to remove these trees has to apply to the entire property. In other words, if you could reduce the size of your development, this is how we interpret it, I'm sure my colleague will interpret it differently. If you can reduce the size of your development or alter or shift part of your development so you don't have to remove the trees, that's not an unwarranted hardship. And that's exactly the case here. You have trees on the boundary of this property. That's the only place. They're not located in the middle. They're not dispersed throughout. They're on the boundary of this property. If this applicant provided more room for buffering, for screening, for on-site preservation by reducing the footprint of the development, they would be able to preserve those trees. The other requirement for a Forest Conservation Act variance is that it cannot be, the reason that you need a variance cannot be a self-created hardship, meaning you cannot, and this is important, your predecessor in title could not have done something to require you to ask for a variance. Meaning if the prior owner isn't eligible for a variance, they can't sell it to you and then you get to be eligible for a variance. And in this case, part of the reason the applicant asserts they need a variance for these trees is because of the on-site stormwater pond. That's not a natural feature of this property. That was specifically created by the prior applicants, the prior owners of this property. Therefore, any need for a variance based on the fact that there is a stormwater management facility on this site is entirely a self-created hardship. It was created by the prior owner, and through the Prosser case that we've cited in our briefs repeatedly, that means it's a self-created hardship. So for those reasons, we don't believe the applicant satisfies the need, the criteria for a Forest Conservation Act variance. I'd like to move on to the traffic piece.
Let me just say, before you move on, I want you to stay focused on why we're here, and that is for the remand.
Yes, sir.
I think a lot of what you're saying is out of the scope of the remand itself. And I can appreciate the quote that you gave of myself. But community engagement is not also part of the remand. So as we continue to go through this process. If you can stay focused on why we're here and what the remand is all about, then I think that quickly we can all get out of here.
Absolutely, sir. And I just want to reiterate the tree conservation variances, those elements I was describing, the self-created hardship and the unwarranted hardship, those are certainly within the scope of the remand, and as well as the compatibility aspect.
I would tolerate for the record just to jump in and provide a little bit of color to what my client is stating. The scope of the remand with respect to the forest, the tree conservation variances, as staff understands it, was to address that zoning variance case law. We believe that addressing that is simple as we all agree that that zoning variance case law is inapplicable. The remand instruction didn't request that the board reopen its other findings on that tree conservation variance.
If I may respectfully disagree, the remand order states, on remand, the board's decision must be precise and clear on the contested issues raised by opposition. That was one of the contested issues that we raised in our opposition, and we've repeatedly raised throughout. My understanding is the issues on remand was just to provide additional clarity on some of those issues, but it did not limit the scope. And again, if you look at the brief transcript or hearing from the district council, Councilmember Harrison stated that he's doing a full remand on all of the issues that were provided by citizen opponents. So I won't belabor the point. I just wanted to make sure I preserve the record that I do believe those are part of the remand considerations. For traffic, I'll be very, very brief, Mr. Chairman. I have a witness that should be online, Larry Green. I just wanted to make sure he has an opportunity to just provide a few comments.
I don't see Larry Green.
Or Lawrence.
I'm here.
I can find it to him.
Can you hear me?
Yes, Larry. We can
Okay,
hear
great.
you. Mr. Green, could you just provide to the board briefly your professional background?
Yes, I am a registered professional engineer in the state of Maryland, as well as a nationally certified professional traffic operations engineer. I have about 39 years experience in traffic engineering and transportation planning.
Thank you. And you provided a brief report that we submitted into the record. Is that correct?
That's correct.
Okay. And I just have one question I wanted to ask you. Did you hear Mr. Lenhart's testimony earlier?
I did. Portions of it cut in and out, but I heard most of it.
Do you recall him noting on the potential inaccuracies regarding the trips that will be generated by the property that will go to the proposed commercial sites? And him saying essentially that those won't be impactful. Do you recall generally that testimony?
Yes.
In your professional opinion, do discrepancies or errors in traffic impact studies, are those meaningless in your opinion?
No, they're not meaningless at all.
Okay, that's all the questions I have. I want to give the opportunity to Mr. Gibbs if he wants to cross-examine.
Mr. Gibbs?
Mr. Green, what errors are you referring to?
Well, specifically, there was two issues that I thought were I wanted to bring up. One was the assumption.
I'm sorry. Can you turn your camera on? Are you
Sure.
in a position?
Sorry.
Thank you.
Sorry. Yes. Thank you. There was two issues that I thought were the primary issues of the December 15th traffic study that I had concerns with. One was the fact that there was an assumption that 10% of the traffic that would be generated by the fast food restaurant would be internally served by the townhouse development. And if you make that assumption or include that in the analyses, it actually results in the traffic generated by the townhouse development to have negative trips, negative inbound AM peak hour trips. the reduction is that great that you would have a negative conclusion of trips being generated by the townhouse development, which obviously is erroneous. The second issue is even for the PM peak hour, if you assume that 10% of the fast food restaurant trips would be served by the townhouse development, it's actually a reduction of about 42%, as high as 42% of the traffic that would be generated by the townhouse development would be served internally by the fast food development, which again, that even 42% is very high and it's really not within acceptable standards. The second issue I had was the fact I understand the mitigation measures at the Maryland 210 and Maryland 373 intersection. The main point of those, or the main operational change, is they changed the signal from a concurrent signal phasing for Maryland 373 to split signal phasing, which means in split signal phasing, each side runs separately. That change is a significant change to the signal. Maryland 210, there's traffic progression on Maryland 210 that when you change it to split signal phasing, that changes the operational characteristics of Maryland 210. That issue has to be analyzed by Maryland State Highway, and they would analyze that before accepting this improvement or signal change. And if the state doesn't accept that, then the site doesn't. You can't mitigate your traffic. So that's an important issue that I felt like the board needed to know, that the state needs to approve this change or the site is not mitigated.
Did you reach out to the State Highway Administration to ask them anything about that issue?
I did not.
Were you here for the testimony of Mr. Lenhart? Did you hear his commentary relative to the discussions he has had with the State Highway Administration regarding this issue?
The only thing I heard is that the state indicated that there would be some operational benefits if the signal was split phased. I didn't hear him say that the state was okay with the signal changes being proposed.
You did not hear him say that the state said that they preliminarily agreed with his assessments? You didn't hear that part of his testimony?
I heard that they were preliminarily agreeing that if the traffic signal phasing change was accepted, that it did appear that there would be operational benefits. That's what I heard.
That's correct. But you didn't reach out and do anything. Did you actually even prepare a report of any kind?
I just prepared a brief memorandum report outlining these two issues.
So your memorandum appears on pages 170 and 171 of the staff backup. It is a page-and-a-half memo with no citations to any trip numbers, no citations to any code provisions, no citations to any of the traffic studies. Is that correct?
It was simply a statement of my assessment of the report. That's it.
And very preliminary at that, correct? Let me. You don't even have to answer that. Let me also ask you. How many traffic impact analyses have you prepared for mixed-use transportation developments in your experience?
I can't say definitively, but I prepared at least probably 30 or 40 of those type of studies.
For mixed-use developments for MXT?
Not necessarily for Prince George's. I've mixed-use developments in general.
How about mixed-use developments in Prince George's County?
That I prepared personally, I don't recall. I've reviewed a lot of those studies, but I don't think I've prepared those.
Well, I understand you've reviewed a lot to oppose cases, but have you ever prepared one yourself?
Again, I've prepared a mixed-use development proposals at many jurisdictions.
Not to cut you off, sir. Not to cut you off. My question was clear. Have you prepared an MXT traffic impact analysis in Prince George's County?
Objection. The way that has answered this question is.
I agree.
did
No, I
you
don't
appear-
believe I have.
Thank you. Thank you very much. And let me ask you a question. Do you know when a traffic impact analysis then is required? Where there... So let me answer my question, please. Thank you very much. Do you know when a traffic impact analysis is required relative to a conceptual site plan for the MXT zone?
I can't quote the actual criteria, no.
May I approach? I don't want to. Sorry, I'm going to object. Again, he's already testified. He has not prepared a traffic impact study for Prince George's County for the MXT zone, and it's also not relevant to his testimony.
It is immensely relevant. He's given critical testimony against the traffic impact analysis in this case, and he has to demonstrate. She's offered him as an expert. He has to demonstrate that he has expertise to criticize a report, and it's obvious he doesn't. And he needs to answer this question because it is highly relevant.
Ms. Green, if you can answer the question, please.
Okay, what was the question again?
I knew that was coming. Yes. Do you know when a traffic impact analysis is required for a conceptual site plan in the MXT zone?
As far as the actual amount of trips that a specific development would meet a criteria, I believe it might be 100 or more peak hour trips, but I'm not positive about that, which this site would generate significantly more than that anyways.
Would it surprise you to know that has nothing to do with trips? So you obviously don't know, do you?
Again, this is a nuance of when or whether a traffic study is required. I'm certainly very experienced and have a lot of experience preparing traffic studies, reviewing traffic studies. So I object to your statement that I'm not qualified to provide these.
Well, thankfully for us, you're not allowed to object. You're allowed to answer questions. And so the answer is you don't know when it is required.
I do not know the specific language about when an MXT requirement is traffic studies required. That's correct.
So then you don't know. You also do not know why it is required, do you?
Again, I can't quote the language of why either.
Well, would it surprise you to understand that the only time that it's required is when for a conceptual site plan is when a property has been zoned pursuant to a sectional map amendment? Have you ever heard that before?
It does sound familiar, yes.
Familiar, but you don't know it.
No, I do not know the exact code of that, no.
Have you, so
Mr. Gibbs, I think your point, you have driven that immensely with this witness.
Thank you, Mr. Chairman.
Thank you.
I really have no more questions to this witness.
Fair enough. Ms. Votas.
Thank you, Chairman. I'll just be brief. Again, Mr. Green, it's your understanding, is it not, that the applicant is required to demonstrate adequate traffic facilities, transportation facilities, when a CSP application is being considered? Is that correct?
That is correct.
Thank you. That's all I have for this witness. And then I have one more witness, Mr. Vic Christensen, I'd like to call.
Yep.
I'm an adjacent property owner of where this development.
State your name, please.
Victor Christensen.
Yes, sir.
I'm an adjacent property owner where this project is being built. And I just wanted to state that communication has not been there despite what the attorney Gibbs has mentioned. Our attorney is correct. We haven't had very much communication. In fact, when they made this new proposal on January 6th, apparently, they sent out some information to some of the citizens. I did not get it. The other adjacent property owners did not get it. We didn't hear about it until the meeting on the 13th, just the other day. And I think that's unacceptable. The other thing that I would like to mention is the traffic on 210 once again. I'm sorry, I'm having a slight problem here. The traffic on 210 is out of control. At a meeting yesterday, Dr. Reverend Screen, who handles the 210 Safety Committee, said that the traffic on 210 in the last 5 years has gone from 70-some thousand vehicles a day to over 90,000 vehicles a day. The infrastructure is just not there to handle that burden of traffic. I would like to compliment the owner of the property, Mr. Jim Clark. I had a brief conversation with him on Tuesday and again today before the meeting, and he's a very amiable guy. We haven't had this type of communication before. He's willing to talk to us, and I appreciate that very much. Just one other comment regarding the traffic. The traffic study was done on December 15th. I'm a former government employee. I've traveled 210 for many years. The government basically shuts down in December. People have use leave, and they use it. The government just basically shuts down, and the traffic is very diminished. I think doing a traffic study on December 15th is probably the worst possible time that you could do a traffic study. And if I could just make one final comment. There's a project going on, and this isn't a criticism, but there's a project going on called the Accokeek Gateway Project. It's a very good project. People in Accokeek love it. It's supposed to maintain the history of the area, maintain that the area be semi-rural, and the centerpiece is that intersection of 373 and 210. That's the centerpiece. That's the centerpiece of the Gateway Project. This project is basically contrary to that. It's basically urbanizing the area, and it's saying that it would be a 24-hour vibrant community, which nobody really wants. So my question is, or my concern is, these two projects don't seem to mesh to me. Yet, you guys are working on these two projects, and it's just kind of confusing. So I think you should consider that. They seem to be at cross purposes. Thank you.
Mr. Christensen, I appreciate you coming in. This is a remand case. And part of that, most of your testimony was involving community engagement. But I wanted to, because you have taken time out of your busy day to come down here to testify, I allowed you to express yourself, and I really appreciate that. So thank you so much, Ms. Votas.
I really appreciate that you let me. Thank you.
Yes, sir.
Oh, no, it's fine.
No.
Thank you. Wrapping up, thank you again, board members, for indulging us and hearing us out on this issue and, thinking critically about this. It's really important to the community that this be thoroughly investigated and understood before decisions are made. And so with that, for all of the reasons we've provided today, for all of the reasons we've provided in our written objections filed 2 days ago, for all of the reasons we've provided previous to that in the original hearing and before the district council, we asked that the district council deny this application, particularly given that the council is reviewing a request for apartments, and the applicant's own counsel seems to acknowledge an incompatibility with apartments in the surrounding area. But, I always like to be as safe as I can. If the board is not inclined to agree with us and deny this application outright, which again, I think there are many reasons to do so, we respectfully ask that you impose conditions of approval at minimum to include the following. 1, any structures on the property be limited to 3 stories high. 2, to require on-site that the applicant meet the minimum preservation requirements. I think it was like 1 acre that staff acknowledged. I apologize for not remembering the amount off the top of my head. Require that preservation to be on site, and or at the very least reaffirm that the applicant be required to provide the landscape buffering that to exceed the minimum amount by 100%, which again is a prior condition of approval that should apply to this property. So reaffirming that. Also including the fence that Mr. Gibbs described. We would also ask that the approval be conditioned on the mitigation of the violative effect of removing the woodland on Lot 12 and out parcel B by increasing substantially the amount of off-site mitigation to be required. We think, again, at minimum, 33 acres for just Lot 12's impact. And then condition approval of any development on this site on the approval and execution of the traffic mitigation measures being proposed. And then finally, again, I think if there's more screening, if there's more on-site preservation, the applicant could be preserving at least the specimen trees or significant trees along the border of the property, so require those to be retained as well. We really appreciate your time. I think I get a closing later, so I might be back up here, but in case I'm misremembering the rules, we really appreciate your time and thank you so much for the opportunity.
Thank you. I believe that you had others that were opposed. Did they want to?
Would you, I'm sorry to ask this of you, would you be able to see if they're online? I know that they're not here today. It's the Dodsons.
But let me ask, is Emily Cavan here?
Chairman Barnes, if a party is represented by Ms. Vota, they don't get to speak.
Okay.
However, the parties that are unrepresented and if they're signed up to speak.
That's what I'm asking.
Yeah. And I can, if you would like me to verify who on the list I represent, I'm happy to do that, or.
Call them out.
Thank you.
It's Emily Cavan. No. Carolyn Keenan. Okay. Tiana Gomez. Is she your client? Yes, ma'am.
Morning, members of the Prince George County Planning Board and members of the community. My name is Tatiana Gomez, and I have lived in Alcoquí, especially Signature Club West, for just over a year. We chose this community because it felt peaceful, safe, and connected to nature. It felt like a place where families.
Can you just put the mic a little closer, because I'm not hearing very well.
Okay. My name is Tatiana Gomez, and I have lived in Alcoquí for just over a year, especially in Signature Club West. We chose this community because it felt peaceful, safe, and connected to nature. It felt like.
Yes, you heard everything she said.
I heard.
Repeat it?
No, keep going.
Okay. Feel like a place where families could build a family and a future. Since last June, when we first saw the hearing signs for this development, the sense of security has started to fade. I attended the hearings, and at the last one, we were told the developer will engage with the community. That did not happen. Most of the neighbors had no idea about meetings or plans. I personally have to reach out and inform people so they could be here. The lack of communication has been deeply discouraging. Since buying our home in February 2024, we have also watched townhouses sit on the market for months, with at least one still unsold today. This tells me that demand here is already limited, and it makes me question why we are being asked to accept a 100-unit multifamily development that will be remove green space and change the character of our neighborhood. We are already feeling the impact. Heavy construction, vehicles, damaged roads, and increased traffic are not part of our daily lives. Just this Monday, there was a car theft on Caribbean Way. These are not abstracted concerns. This is our safety, our children, and our quality of life. I ask the board, please consider the people who already live here. What is the real plan to support schools, first responders, roads, and public safety? Without clear and enforceable solution, this development feels less like progress and more like a risk to the community we chose and love. Thank you.
Thank you.
Thank you.
Jordan Edwards. Got it. Julian Dotson. Standing. Raina Dotson. Good stuff. Khalid Dawson.
Hello. Hello, this is Raina Dodson. Hi.
Is she your client?
Can you hear me?
Okay. No, we don't need you.
Okay.
Thank you. Monica Barnes. I believe that's all that I have. That it. Your name?
Michael Lowenthal, party of record. Thought I signed up to speak.
No, sir. Hey.
Okay to speak.
No, sir. All right, Mr. Gibbs.
Mr. Chairman, I don't have anything further to add. I'm ready to sum up here, although I would say this. My client and I have been criticized for alleged lack of community outreach, which we take massive umbrage with. We would like to reply to that, but you have said that it's really not relevant, and so we won't. But we take massive umbrage with that comment. With that being said, we're ready to sum up, and so I think since I go last, it would be appropriate for the other council.
Thank you, Mr. Chairman, members of the board. Again, we believe the board has numerous grounds that would require denial of this application. In the event that the board doesn't, we provided those proposed conditions. I think they would address, at the very least, the compatibility issue, which is a required finding. The board would have the authority to impose those conditions, and we appreciate the board's time and consideration. Thank you.
Thank you. Mr. Gibbs.
Thank you, Mr. Chairman.
Before you begin, I have one concern, and I don't know how it can be resolved. I understand Mr. Lenhart's testimony, and I appreciate that, but I'm well aware of the traffic situation on 210 and 373 since I'm a resident in that area. So what happens if the State Highway Administration does not allow the signal change? Can you proffer some language that Mr. Lenhart or whoever you choose to would communicate to the State Highway Administration the importance of that, and that the project is being approved as a condition?
I'll be happy to we're more than happy to make that communication with the State Highway Administration. We are, regardless of the legalities, we're 100% on board with those mitigation measures, and we are going to do everything in our power to make sure they happen. We will continue our outreach to the State Highway Administration. I will join personally with Mr. Lenhart in discussing those issues further with the State Highway Administration. And I quite frankly have very little doubt that there's going to be any problem with that.
Thank you.
Yeah, I'm going to be brief as well, Mr. Chairman. I appreciate the patience that the Planning Board has displayed allowing us to put this information on. I do want to thank the staff. In this case, I think they did just an outstanding job going through the remand issues that when this case was sent back by the District Council. I think that the staff report that's been published is well-reasoned, thoroughly supported by the evidence. Again, when we went to the District Council, we specifically said, please send this case back so we can straighten out this issue on tree conservation. And we have done that. The staff has gone back. I mean, the tree conservation plans are really for a 343 acre property. and they've evolved over the course of time. And so staff had to go back and look at all those tree conservation plans, 1, tree conservation plans 2. They had a very detailed analysis in the staff report. And quite frankly, with possible some minor exceptions, we embraced and agreed with all those. So much so that we understand there is some tree conservation that has to be prepared off-site, which is, our right to go off-site for that. It's not our responsibility for Lot 12 and out parcel B. We don't create that responsibility, but we're accepting it. And we're going to go off-site and take care of that, in addition to taking care of the tree conservation, the 1.61 acres, I think it is, that this particular project generates. But there's additional above and beyond that, and that is a condition in the staff report that we accept. And we want to do the right thing. We want to make sure it happens the right way. But it's very, very important to bear in mind that when you go back and look at all the tree conservation 1 plans, okay, which is really the base that you start with, and when you look at the site plans and the resolutions of approval for the site plans, not once in anything that we looked at that's in the record, not once did we find anything other than an affirmation that this property was going to be the subject of commercial development at that time, because it was approved for 157,500 square feet. That's just Lot 12 alone. Nowhere in the record do we find any reference whatsoever that this property cannot be developed and it has to be permanently tree preservation. It was always just a placeholder to carry forward because this was such a major development. And it wasn't carried forward in every instance. In some instances, the offsite mitigation and easements occurred. But this is what we were left with. This is what we have to accept, and we're going to take care of it. But nowhere, every place you look at plans and it says, these are tree conservation plans with stamps on Lot 12, future commercial development or future development area. The resolutions, including the one that I presented to Mr. Ferguson today, but the most recent resolution, December of 2017, clearly says Lot 12 will be developed with commercial uses. It was never the intent that this property was going to be burdened by 12, 14, whatever acres to be preserved on this site. It was always part of the plan that this would be part of the development of Signature Club. So we think that's clear. We accept what the staff has in their report. We think we've supplemented that with testimony from our witnesses. We embrace, I made a commitment to Mr. Christensen and to Ms. Keenan and Mr. Eberg that I would proffer that condition relative to the screening along the north-northwest property boundary, the entirety of it, and we would recommend that. The conditions that counsel for the opposition parties has just proffered, I've never seen it, never been presented to me. I've heard her read them here today for the first time. We can't agree to those at this point in time simply because we haven't even had an opportunity to look at what their impact might be. And there are we got to come back for a preliminary subdivision plan before you. We have to come back before you for a detailed site plan on this project. These conditions, if they're going to be implemented, are more appropriate to be implemented at later stages in the process. I'm not saying that we wouldn't agree to all of them. But for instance, I can't agree to 33 acres of preservation when that applies, that resulted from TCP1 plans for 343 acres. We don't even know where that's been taken care of already. So respectfully, I don't think those conditions are appropriate to be added at this point in time, and especially when the first time we hear about them is 10 minutes ago. Thank you very much.
Thank you. Are there any questions? The hearing is now closed. First, I want to thank everyone for coming out today and providing their testimony. As a reminder, this is a conceptual site plan, the first step in the process for this development. To develop this project, the applicant will need to return to this body again for additional approvals. This will represent another opportunity for the community to be engaged with the applicant, staff, and the planning board. As stated at the beginning of this hearing, this remand was limited to taking testimony on 9 issues raised in the district council's remand order. Based on the testimony and argument we have heard today, I am inclined to update the findings in our resolution and include the additional findings and conditions recommended by staff. Commissioners, are there any other discussion?
I have none, Mr. Chair. I'm ready to make a motion.
If so, what's your motion?
Okay. Mr. Chair, I move that we reapprove CSP 23-002, TCP 1-052-97-03, and a variance from section 25-122B1G, and amend resolution PGC-PG 2025-057 to reflect the additional findings of staff as amended by staff's presentation, and additional condition 1E as read into the record by staff, and a further condition proffered by the applicant to provide screening along the northern property of lot 12 and outlot B.
So move here. Been properly moved in second. I will now call the roll. Vice Chair Giraldo.
Vote aye.
Commissioner Okoye.
And I vote aye.
And I vote aye as well.
Thank you very much. Have a nice day.
Thank you. The next item on the agenda is item 6, draft resolution PGCPB numbers 2025-057A CSP-23002, Signature Club East.
Mr. Chair, I move that we.
Sorry, Commissioner Trumbull, Mr. Huang has brief remarks.
Before the board make motion, step 1 to request to incorporate the testimony discussing in the item number 5 and make the correction to the amended resolution.
I would move that we adopt the amended resolution of CSP 23002 and adding the proffer made by the applicant regarding the screening along the northern side of the properties of lot 12 and lot 8, outlot B.
Yeah, it's been properly moved in second. All in favor signify by saying aye.
Aye.
I will now call the roll. I'm sorry. Commissioner Giraldo.
I vote aye.
Commissioner Okoye. And I vote aye as well. That concludes all items on today's agenda. I want to thank the staff and others for coming out today. The time is now 12:15. The meeting is now adjourned.